Sage Advocacy is the national advocacy service for older people. It also supports vulnerable adults and healthcare patients in certain situations where no other service is able to assist. Sage provides information, support and advocacy, and our work on behalf of clients is independent of family, service provider or system interests. Our team of experienced advocates is available right across the Republic of Ireland, and our service is free of charge and confidential. Sage Advocacy ensures that a person's voice is heard, that their wishes are taken into account, and that they are assisted in whatever ways necessary to be involved in decisions that affect them, whether they are at home, in a nursing home or in hospital. Our work is guided by quality standards for support and advocacy work with older people, a case management group and a policy and practice committee. Our motto is simple: nothing about you without you.
In 1871, 1 year after the death of Charles Dickens, the Lunacy Regulations Ireland Act became law in Ireland. It created a system of wards of court based on people being declared of unsound mind, and it focused on the control of assets, money and land, and on people in authority deciding what was in our best interests. Over 150 years later, much later than most other developed countries, we now have legislation reflecting the democratic instincts of our time. It is subtle rather than simplistic, and it places an onus on all of us to presume capacity to make decisions rather than rush to question capacity. Terms like unsound mind and best interests are gone. People who are currently wards of court are having their cases reviewed. Advanced healthcare directives have legal standing, and powers of attorney are being refined. Above all, we have an agency of the state, the Decision Support Service, to inform, support and regulate the system provided for under the legislation. The legislation reflects the learning from other countries. Ireland, once a laggard, is now a leader. It has clearly stated guiding principles, of which the most important is the presumption of capacity to make decisions. It is something of which we can be justly proud.
If you're an older person in Ireland and you can't momentarily remember a name or where you put something, it is common enough to say, "I must be losing my marbles." It is usually a light-hearted way of expressing a concern about memory loss or increasing difficulties with making decisions. But there can be a darker side to this issue. Family members, neighbours or service providers can, on occasion, take advantage by exaggerating the problem for their own benefit. Sometimes even well-meaning people, including our loved ones and health or social care professionals, think they know what is best for us and start taking control over the decisions we should be making. In effect, stealing our marbles. New Irish legislation helps to protect our marbles by providing a framework to support decision-making according to our circumstances. It is a move from the simplistic all-or-nothing approach of the 19th century to a more subtle, rights approach which emphasises the positive rather than the negative, which takes into account what is left while being mindful of what has been lost. It is all about assisting decision-making and a functional approach to assessing capacity. There are 5 different types of support for decision-making provided for. Green. A decision-making assistant is appointed by a person to help obtain, explain information, and communicate a decision for them. The person still makes the decision. It is an informal arrangement. A decision-making assistance agreement is a written agreement a person prepares in which they identify one or more people they trust to act as a decision-making assistant to help them make decisions. In the agreement, a person can choose what decisions they need help with, including, for example, financial matters. Amber. A co-decision maker is appointed by a person to make decisions jointly with them as a co-decision maker. This can be used where a person feels unable to make decisions on their own. This is a more formal arrangement which is registered with the Decision Support Service. A capacity statement is required and the co-decision maker reports to the Decision Support Service. A co-decision making agreement is a written agreement. Red. A decision-making representative is appointed by the courts following an application to the courts for a decision-making representation order, which is limited in time and scope. If the court does not make a decision itself, it appoints a decision-making representative to make certain decisions on a person's behalf, taking into account their wishes. This can help if a person is unable to make decisions, even with help. The person appointed by the court can be someone known to the individual and trusted by them, or a person from a special panel who is trained for the role. The order is registered with the Decision Support Service, and the decision-making representative reports to the Decision Support Service. Red. The two other types of decision support are an attorney appointed under an enduring power of attorney and a designated healthcare representative appointed under an advance healthcare directive. The types of decisions covered by the legislation includes personal welfare matters which can relate to accommodation, including whether someone should live in a designated care centre, to participation in employment, education, training or social activities, decisions on social services and healthcare. Decisions can also cover property and affairs including buying, selling and managing property, or carrying on a business, making an application for housing, social welfare or other benefits. Decisions excluded from the legislation include marriage and divorce, consent to sexual relations, jury service and making a will.
An important feature of the assisted decision-making legislation is that there are guiding principles. We must presume capacity. We must take all practicable steps to support a person with making a decision. There should be no intervention unless it is necessary. Importantly, the guiding principles make clear that an unwise decision does not mean that a person is unable to make a decision. Indeed, which one of us has never made an unwise decision? And if we have, no one then told us that we couldn't make any more decisions. The guiding principles also make clear that any intervention must minimise restriction on a person's rights and freedom of action, have due regard to a person's rights to dignity, bodily integrity, privacy, autonomy and control over their financial affairs and property, be limited in duration, be proportionate, facilitate participation, and take into account past and present wishes and beliefs and values. Above all, they require that we act in good faith and for the benefit of the person.
Codes of practice. Codes of practice have been developed by the Decision Support Service, the most important of which is the Code on Supporting and Assisting Decision-Making. There are also codes for healthcare professionals and advance healthcare directives, legal practitioners, attorneys, financial professionals and financial service providers, independent advocates.
Assisted decision-making legislation provides a strong foundation for our clinical work and the culture of care that we seek to nourish. Our approach stresses the importance of respecting the right of a person to make decisions for themselves, to be informed about their options in a way that's easiest for them to understand, to support them in making the decisions and to record the medically relevant parts. The approach of informed consent and supported decision-making is now reinforced by legislation. We have the legal change, and now we need to work on the culture change. Part of that culture change is focusing on how well we assess people's capacity to make specific decisions that need to be made. And I cannot stress this strongly enough. The functional approach to assessing capacity to make a decision is not exclusively a medical test. Health and social care professionals, people providing financial services and solicitors and independent advocates can all, with the necessary skills and interest, play a role in assessing a person's capacity to make a particular decision. So the old all or nothing approach where a doctor exclusively declares that because you lack the capacity to make a particular decision, you lack the capacity to make all decisions, that's gone forever.
A capacity assessment is not an exam to find deficits. It is not a memory test. It is not a question of lack of insight. It has nothing to do with mental illness or assessment under the Mental Health Acts. Sage Advocacy has developed an approach to help understand and carry out a functional capacity assessment. It is called ALERT. In engaging with a person who may have diminished capacity to make a decision, it is important that we ask, what is your understanding of what you have to decide? Listen. Pay attention to words, feelings, body language and other forms of communication. Explain. Explain everything, including all the choices, in a way that the person can understand, or ask someone else to help, such as a key worker or independent advocate. Reality check. Go through all the possible choices and consequences. Summarise. Tell. Tell me about your decision, why that particular choice is important for you, and how you came to this decision. Assessing a person's capacity to make a particular decision, often a very important decision, requires patience and a willingness to work at finding attributes rather than deficits. A decline in capacity does not mean a decline in rights. It is about seeing the light and not just the shadows.
As an older person who has in recent years acted as a support and advocate for other older people, some of them younger than me, I'm well used to hearing people tell me they know what is in another person's best interests. Quite often, they're confusing their own interests with the other person's interests. They find it hard to accept that another person has the right to make a decision that is different to what they might themselves make in a particular set of circumstances. I want to be able to make decisions for myself for as long as I can, but for whatever reason I'm unable to make decisions for myself, I want there to be a means by which my will and preferences, my wishes, can be taken into account. It's one thing losing your marbles, it's another thing having them stolen. This is all about helping people mind their marbles.
Sage Advocacy. Nothing about you without you. www.sageadvocacy.ie